During a deviation period or any dictatorship, the judiciary is not independent and they don't decide independently. That's a big assumption that you're throwing at us. You're saying that in any martial law, the judiciary is not independent. Hence, this is not a fair trial. You'll have to build a very strong case that how do you break that assumption that the judiciary is independent even during martial law period? And if it's not, what's the evidence? And if it's not, then what is the consequence? But that's a big assumption you're challenging. You're saying that in any deviation period, the judiciary is not independent. That's a big assumption to touch.
It was written to them. I think so. This is what I've not seen any document.
We'll find out.
See, the registrar has to be written to bring the document on the record.
Many years have passed.
Yes.
Now, please, anything else you want to refer to?
And para 3 also, my lord.
Yes, read it.
It is important to note that 3 cases were registered.
These cases
were registered during the pendency of the trial of the murder case by the 5-member bench of the Lahore High Court. Therefore, we consider it appropriate to look into this record as well, because it is also likely to throw light on the facts and circumstances of the reference. 4. The Secretary, Ministry of Interior, Government of Pakistan, and the Home Secretary, Government of Punjab, are directed to procure copy of the order passed by the martial authorities under MLR 12 of 1977, along with copies of...
I must stop you now. If you want something specific sent for, please submit an application or give us particulars, this, and who can we direct to send it for? We'll pass such an order.
I'll do it, my lord.
If it is not available, we can't do anything about it.
Your lordship is right. I'll move a proper CM listing the documents which I want to be...
ठीक है, हो गई ना बात.
ठीक हो गया.
Not only that, just don't say I want this document. You have to say where
they're lying.
Would it be?
Definitely, I've got to show where they're lying.
One second. Now, anything else in the order that you want to read out?
My lord, just one point, just by way of information. The report, Justice Shafiur Rahman Tribunal report, was the government at that time, both the federal and provincial governments at that time had decided to make them public in 2011 during the course of proceedings of this reference.
So if it's public, then we'll have it?
Yes.
Somewhere or the other?
Gigi, it is duly recorded in paragraph 7 of the order which my learned friend was reading out. Now, the only thing which is not available is the complaint, the record of complaint.
We've understood. Anything further?
That's all. That's all.
Okay. Anything you want to say? No, now I'll just say let me just consult.
Okay.
अटॉर्नी जनरल साहब, ये कंप्लेंट जो आप कह रहे हैं बार-बार प्राइवेट कंप्लेंट, इसमें तलबी हो गई थी मुलजम की?
एक तलबी हुई थी, ये पहले सेशंस में हुई थी, वहां से फिर ये हाई कोर्ट आ गई थी. एंड देयर वाज अ 2-member bench of the high court headed by Mr. Justice KMA Samdani at that time, who was seized of the matter on private complaint. अच्छा, जब ये प्राइवेट कंप्लेंट एट वन एंड चल रही थी, तो नीचे जब ट्रायल स्टार्ट हुआ, तो ट्रायल जो है वो हाई कोर्ट ने अंडर 526 अपने पास मंगवा लिया. तो उस वक्त चीफ जस्टिस ने 13 सितंबर 1977 को ये ऑर्डर किया कि ये अब यहाँ चलेगा. सो वो ट्रायल तो उधर चला, फिर वो प्राइवेट कंप्लेंट का पता नहीं लगा कि क्या हुआ उस 2-member bench.
ट्रायल के साथ मर्ज नहीं हुई एफआईआर और प्राइवेट कंप्लेंट.
I have not seen it from the record.
नई केस के तहत फिर कंप्लेंट पे पहले कार्रवाई होनी चाहिए
जी. वो फिर वो रिकॉर्ड में नहीं नजर आ रहा कि
किसी ने ऑब्जेक्शन किया डिफेंस साइड से, किसी ने कहा कि वो कंप्लेंट भी पड़ी है, इसको इकट्ठा रखे और उसको लगाएं पहले.
सर, जब एविडेंस पढ़ेंगे तो पता चल जाएगा उसमें ऑब्जेक्शंस दिए गए हैं.
Mr. Attorney General,
When we read the evidence.
Farooq Naik sir, just to get the course right of this matter, I think the first question you have to answer is the maintainability of this review, and we'll come to the facts later of the reference. So you'll have to assist us that under 186, what's the question of law? Because a decision has been given by the Supreme Court, review has also been dismissed. Now, that is the end of the matter. On what principle? आपके जो grounds अभी तक आपने दिखाए हमें, they are talking about as if you are vesting us, your argument is as if Article 186 vests another appellate jurisdiction to review the existing judgments of this court. And all the grounds that so far that we've seen are factual relating to the judgment itself. Now the question is, there is finality attached to the decisions of the court, right or wrong. There could be bad decisions passed by the court, they're final. So the question is, what is the question of law that is for us to give our opinion on, when the matter has already been settled by the Supreme Court. So if there is a question, you'll have to articulate. Is it outside the judgment, or because the factual position of the judgment cannot be touched? That's been decided. Review dismissed. That's the end of the matter. And we have no jurisdiction to review second review or look at it through a second appeal. There is no such concept under 186. So 186 at best would be a question of law which you will have to articulate before us. It cannot arise out of the factual position of the judgment because that's settled. We can't look at the facts. You'll have to go outside if at all there is any argument, which I don't see in the ground so far. So that's a difficult question. We already have decisions of this court and of the jurisdiction from India also, which say we can't touch a judgment given by this court and look at it at a policy level. If this happens, then tomorrow there could be references, we keep opening all our judgments. So you'll have to really articulate a point under what basis do we go into 186, which I would imagine is a difficult one. So please concentrate on the maintainability and the constitutional question. How do we open this matter, if at all? How?
Your Lordship is right. See, under Article 186 of the Constitution, 3 tests have to be met before an opinion is given. It should be of public importance and question of law is involved. And if these 2 tests are met, then the 3rd test is with regard to giving an opinion by this Honorable Court.
Mr. Naik, the 186 says that the question of law is for the court to determine.
Yes.
The question of public importance is for the president to determine. That's for the president. We don't. That's not our problem. Our problem is what's the question of law? Is the question of law saying this judgment is wrong? Is that a question of law? That is not, to my mind, frankly, speaking for myself, does not constitute a question of law that the judgment is wrong. There has to be more than that, and you'll have to come up with that argument as to what it is. Because if this is the policy, then tomorrow the president can start sending references and start revisiting all the judgments that we've ever given. That will not be a correct way of going about it, and you understand that.
I understand what
so you'll have to come up with something to tell us. What is that novel argument that shows that 186 can be invoked in this matter? So please, this is not easy.
And one thing I would like to add, Attorney General,
to decide anything, we have to opinion.
Yes, my lord.
Therefore, what has been said till now, that relates to the determination of something by this court. That is not the scope.
It's actually a very serious question. Because when you say it's a question of law, the law has been decided in the judgment. Whatever judgment Supreme Court gives is the law of the land. So this is the law. So what's the question of law? So you can't say this judgment is wrong. It's not a question of law. There has to be something else.
Basically, the entire reference is based on the interview of the judge. Qazi Faez. That can be a question of law because it was a factual aspect that has been interviewed by some TV reporter after his retirement. And whether this can be a question of law because the entire reference, the crux of the reference is based on that interview. You have to address that, whether it will be converted into a question of law, whatever he has said. Because there were 3 dissenting judges also. He could have been a dissenting judge of that.
My lord.
What was the pressure on him? Why is...
Mr. Naik, let me take you to the real, what you think your question is. Your question is that during a deviation period or any dictatorship, the judiciary is not independent and they don't decide independently. That's a big assumption that you're throwing at us. You're saying that in any martial law, the judiciary is not independent. Hence, this is not a fair trial. You'll have to build a very strong case that how do you break that assumption that the judiciary is independent even during martial law period? And if it's not, what's the evidence? And if it's not, then what is the consequence? But that's a big assumption you're challenging. You're saying that in any deviation period, the judiciary is not independent. That's a big assumption to touch.
I will try to persuade your lordship on this point.
Can I just, before we get into... we're not...
Other things will follow.
Okay, now I think my brethren have raised some very important questions, and you also realize the significance of these questions. We need not tell very experienced counsel standing before us. There are undoubtedly constitutional questions involved, and we need 2 kinds of assistance. One on the constitutional plane, and the other, if you overcome the constitutional plane questions of questions of maintainability, then expertise on the criminal side. So I've noted that there were a number of constitutional experts who are no longer in this world. So I think we need to maybe appoint a few experts on both the matters as constitutional as well as the criminal. We'll first hear the constitutional experts, and then, depending on where we stand, proceed to hear the criminal experts. So I observe a notable constitutional lawyer, Mr. Raza Rabbani. Mr. Raza Rabbani, would you be willing to be appointed as amicus? Ji? But we want thorough, we'll extract every ounce from you. It may not be a pleasure by the end of it.